Okay, the Committee on Judiciary and Hawaii Affairs is called to order. It's Tuesday, March 15, 2022, 2 o'clock in conference room 325. Yes, we are live and in person. Okay. First bill on the agenda today, SB 2111, relating to public notices. Vice Chair.
First up, we've got DLNR in support over Zoom. You're muted.
Thank you.
So, okay.
Aloha Chair, Vice Chair, and members. I'm Tue Mar from the Department of Land and Natural Resources. The department will stand on its written testimony in support. Thank you very much.
Okay, thank you. Next up, we have the Department of Health in support.
Good afternoon, Chair, Vice Chair, members of the committee online and in the room. My name is Lauren Kim. I'm the Policy and Planning Officer for the Department of Health, here to describe our strong support for this measure. The intention, I'd like to clarify some highlights on my, I'd like to highlight some things in our testimony. This bill is intended for routine, generally technical announcements that the federal government, usually the EPA, but other federal agencies require us to post. I provided some examples for you. I'll just read one. Modifications to portable crushing and screening plants, specifically the use of water suppression to mitigate fugitive emissions for a 253 TPH power screen max track crushing plant and a 441 TPF power screen chieftain screening plant. And there's several, that's a direct quote from the public notice. Out of scope for this would be Chapter 91 hearings for administrative rules and contested case hearings. So the stakeholders which would be impacted by this would be those who are generally employed and paid to do government relations or to watch government regulations, or maybe advocates who are already familiar with knowing to look where change in government regulations occur. This is not intended to affect auntie and uncle who get their information from the newspaper. Again, these are for well-regulated industries, for postings that would be required by, in this case, the US EPA, but other federal agencies. And it would save us money. We provided some estimates on the annual savings. Those annual savings obviously can be used to provide more neighbor island inspections or local community education efforts on EPA and environmental protection. And so we hope you agree with us that this is a common sense administrative simplification and government efficiency measure with very limited impact on the dissemination of information for programs that would be near and dear to everyday Hawaii residents. Thank you, and I'm available for questions.
Good, thank you. Next up, we have Column Software in opposition over Zoom.
Hey folks, my name is Jake Seaton. I'm the founder and CEO of Column. We operate a software platform that just went live in Maui and is currently processing all of the public notices that are placed there in the Maui News. We're a team of software engineers and designers and operators that have been really focused on building software that serves the people that have to go through these notification processes and helping automate their workflow and make it more efficient. With Column, it's gone from about an hour on average to place one of these notices to about 5 minutes. And so on top of that, we've built kind of a centralized statewide database of these kinds of notices for the types of professionals that were referenced that need to be able to find them in one central location. And we've done that for about 15 different states now. So we're really just getting started in Hawaii with this initial go live in Maui, having been really the first usage of our platform in the state. And we're really excited about the value that we might be able to bring from centralizing this in Hawaii, as well as by creating this efficiency from the existing process. And because of that, are opposed to the bill.
Okay, thank you. And testifiers, I always forget to mention, but please try to limit your testimony to 2 minutes out of respect for the other testifiers behind you. Next up, we have Common Cause Hawaii with comments.
Good afternoon, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. It's good to see everyone in person again. We just provided comments on SB 2111, given the importance of broadband and connectivity in recent times. We just want to make sure that this bill does not impact highly critical and time-sensitive matters. We've enjoyed working with Department of Health and Mr. Kim on proposed amendments that were adopted in prior drafts. And we just want to make clear that this bill is just for routine and non-critical notices. Thank you very much, and I'm available to answer any questions.
Okay, thank you. Next up, we have the Star Advertiser in opposition over Zoom.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, Lori Lum on behalf of Oahu Publications testifying in opposition to Senate Bill 2111, Senate Draft 2. OPI publishes 4 of the 5 daily newspapers in the state, including the Star Advertiser, Garden Island, Hawaii Tribune Herald, and West Hawaii Today. And we actually have a total combined monthly view on our websites per month is 28 million. And anyone can view these ads, not just subscribers. You don't need a password or subscription. The intent of most legal notices is to make a valid attempt to reach the largest general public audience possible. So we question whether this bill will accomplish that intent. And a shift to an internet-based publication would disproportionately disadvantage low-income residents and rural communities that have less access to the internet. Finally, a significant number of kapuna do not even use the internet at all. So for these reasons, we ask that you hold the bill. Thank you for the opportunity to testify.
Okay, thank you. And we have one individual here to testify, Peter Fritz, in support.
I'm here. Sorry, I'm still not used to remembering to turn off the mute button. My name is Peter Fritz. Good afternoon to Chair, Vice Chair, and members of the committee. I made some comments and suggestions regarding ensuring that anything that's published online would be accessible. But I'd also like to make another point. This bill doesn't define days. And if somebody right now wants to publish in the newspaper, they walk into the newspaper, they make the commitment in advance to publish on a particular day, which might be 30 days in advance, and it's published in the newspaper on the day 30 days in advance. The way this bill is written at this particular time, somebody could post a notice on the 30th day at 11:59, meaning that they would shorten the full period of 30 days that people might have to observe and to respond to the particular ad. So I strongly suggest that consideration be given to defining what is an accessible public notice, as well as defining what constitutes being published on time. So we're not shortening the day. Thank you very much for the opportunity to testify.
Yeah, thank you. Is there anyone else here to testify on this measure? All right. Seeing none, we'll move on to SB 2390 SD2 relating to the judiciary. First up, we have the judiciary in support.
Good afternoon.
Oh, I'm sorry. I forgot about questions. It's been a little while. That's what having a kid does to you. Members, any questions? Sorry, Jimmy.
Maybe you shouldn't ask questions because I think what happened to the bill the first time.
Do you have any questions, Jimmy?
I do actually. Sandy.
Yeah, sorry. It's been a little while. I had a kid in the meantime.
Lauren, can you call Sandy? Sure. I'll make it quick. Oh, Lauren.
My mistake.
No, Lauren. I want to ask Sandy.
Oh, which one had Sandy's question?
Hi, Ms. Ma. So, in your testimony, and I know a lot of your advocacy is for seniors and people who are not connected to the internet, is one reason that this bill has, we have concerns with the bill. And you were here, you were on the screen when we had the same bill in the House. Now, when you look at the language of this bill, do you feel that this is going to achieve anything as far as what the departments want to have done? Want to achieve? Because I think we can do all of this without a bill. We can do some of the evaluating and documenting of the rationale, and we can do a lot of this without the bill. my concern has been and is that if you pass this bill, some of the financial notices that get out there, people are not going to go look on a government website or an official website to find that information. If somebody's owed money and, you know, people, they're not going to be browsing around that. Seniors have predominantly been known not to browse the internet, the ones in my community anyway. And I'll give you a perfect example. This is the #1 thing that is circulated in our newspaper on Hawaii. And all of the seniors look for this. They walk around Longs with this. Longs was going to discontinue this in the state of Hawaii. They've discontinued it in 49 states. But when it came to Hawaii, because the seniors wait for this every single week and walk in Longs every single week with this, they didn't continue. They didn't discontinue this in Hawaii, but they did in 49 other states. So back to the question, do you think in reading the language, that we need this bill to achieve anything that some of the departments are trying to achieve?
Thank you for that question, Representative Tokioka. So I cannot speak for the departments. What I am advocating for is that broadband is a necessity in our present day democracy. And if your constituents are not able to have access to reasonable, reliable broadband in order to find out the information that's necessary for them from the government websites, then this may not be the appropriate bill to achieve that proper end. And so that is for you as the representative for your district in order to decide. We just want to make sure that the documentation is in place so that as we progress in our society and more broadband becomes available and more people get trained on how to use computers and access information on the internet, that the documentation is there, that departments are able to fulfill that mandate of having non-critical information be available to the public, if that is what this committee decides to move out as a bill. I hope that answered your question.
Yes, thank you.
Thank you.
So, Chair, can I ask Lauren a question?
Yes.
Lauren, the first part of my question was aimed at you since you were there too. So how do you think this, and I read your testimony, how do you think this is going to achieve what you guys are trying to achieve? But it seems like it's a step to the next step.
Well, one of our primary goals for this is administrative simplification and preserving precious general funds that you appropriate to us. Again, one program can save up to 6 figures, and that we can use for operations and for government regulatory activities. It was very easy to negotiate with Common Cause because the Department of Health is also the Department of Health Equity. We don't want to leave anybody behind. So when she brought it up, I said, what do we need to do to make sure rural communities in particular, those without robust broadband infrastructure or people with digital literacy, aren't left out? And I think the first way to achieve that is by requiring that only highly technical posts, routine technical posts, in our case, required by a federal agency. I don't know about DLNR and whether they have federally mandated community right to know, but there's actually an algorithm that the US EPA that I'll send to the committee at the chair's request that shows when you need to post something. And the federal government allows online only. So we would be aligning with that standard. So that's one of the first safeguards. The second would be doing a study of broadband using DCC as broadband maps to look at the relative penetration of broadband into communities. We have no problem with making this machine readable for those with visual or hearing impairments. We also agreed to a suggestion by Common Cause to post in the newspaper for a year ahead of time, saying this is going to go away in a year, this is going to go away in 6 months. If you have an issue with that, let us know. To give people a heads up that in a year, this newspaper posting will no longer be there, and we're going online only. So come have a chat with us and convince us that this is going to be injurious to your community. So we agreed to that. We don't want to leave anybody out. And again, if it's a hearing for administrative rules to change eligibility for SNAP Ed, we want as broad input as possible. But
Right.
my guess is that there are only 100 people who know what a PowerMax screening machine is. And that particular notice on that particular day for that particular job, there's maybe 10 or 15 people that actually care. So, yeah, so we are open to more safeguards to make sure auntie and uncle in Anahola aren't left out.
Yeah.
That is definitely not our objective. But we do think we can have some cost efficiency and bring us into the 21st century with very routine, highly technical postings.
I believe that too, Lauren, but in some of the financial stuff, I don't know, we got to define it better than what this bill says. You know, for the Department of Health, maybe. And in my district, probably according to AARP, the third highest AARP members live in my district. So those types of communities, it's critical that they have this and they have the legal notices.
So maybe an idea that I can toss out is we use US Census designations. That might be a way. I mean, we'll save a ton of money just by going online only in Honolulu, where there are lots of options, and we know that broadband is quite robust. But using criteria such as US Census tract designation as a rural area or frontier area, that might be a way to kind of shrink the unintended consequences which we jointly want to avoid. Again, the nature and I think refining the definition to either include required by a federal agency or highly technical and routine in nature, unlikely to be disruptive to the general population. We're very open to those sorts of things. The opportunity to save money is too great, but also the opportunity to cause no harm is something we're very interested in.
I'm not advocating for neighbor island only because I know there's people on this island too.
Yes.
So anyway, thank you for your testimony, Lauren. Thank you, Chair.
Members, any other questions? Rep. Nakamura.
Yeah, actually, just a comment commending Common Cause and Department of Health for working together because we knew this was an issue. And we just thank you for at least finding some common ground here to move forward. Mahalo.
Members, any other questions? Seeing none, we'll move on to SB 2390, Sd2 relating to the judiciary. First up, we've got the judiciary in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, members of the committee. Good afternoon to each of you. My name is Lisa Ginoza. I'm the Chief Judge for the Intermediate Court of Appeals, and the judiciary is in strong support of this bill. And we appreciate that it has been set for hearing. In my testimony, I tried to set out a little bit about the history of the ICA, and I will just try to highlight a few things. So the ICA, came out of the '78 Constitutional Convention, got underway operating in 1980 with 3 judges, 1 chief judge, 2 associate judges. And over the course of the next 24 years, 3 additional judges, associate judges, were added, so that as of 2004, we got to our current number of judges, 1 chief judge and 5 associate judges. What this bill does would be to amend the statute and would increase it so that we would have 1 additional judge, as well as appropriate funds for that judge and necessary support staff. We have been at our current number of a total of 6 judges for almost 18 years. And a lot has changed since then. In 2004, when we got our last 2 judges appointed, we were under the old appellate system where cases would get appealed to the Supreme Court, passed down to the ICA. Since then, we have changed the appellate system so that most of the appeals come directly to the ICA, and then there's a discretionary appeal to the Supreme Court. That has really changed the workload, the structure, the preliminary motions, and a variety of other things that have to be done with regards to each appeal. So for the last 15 years since we changed that structure, I tried to capture in our testimony. The ICA has had over 8,000 appeals filed in the court, has resolved most of those, close to 7,800 of those appeals. That leaves a little bit of a bit that we weren't able to, but the historic backlog still exists in our court. If there is a realistic opportunity for us to get at that backlog. It is to have another judge. And so we really, really appreciate that this bill is moving forward. We request the appropriations be restored and the effective date be restored to the SD1 version. Mahalo very much. I'll be available for questions. Thank you.
Okay, thank you. Members, that's all the testifiers we have today. Is there anyone else here to testify on this measure? You see none, members, any questions? All right, seeing none, we'll move on to SB 2087 SD2, making an appropriation for the Victim Witness Assistance Program. We have one testifier here today, the prosecuting attorney of the Department of the Prosecuting Attorney of Honolulu in support.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. The department is in strong support of Senate Bill 2087. This is part of our 2022 legislative package, so we appreciate the committee for hearing this bill. Our Victim Witness Assistance Program plays such a pivotal role for victims of crime, assisting them with funding, with support services, trying to assist them through sometimes confusing process of our judicial system. I would note in this bill, this as well as the bill that follows in Senate Bill 2088, that was originally, and our department is very aware that the last few years funding has been such a huge issue for a lot of departments, but our funding was originally the base budget for all the different counties was placed in the ATG 100, the Attorney General's budget. During COVID times, that budget was zeroed out. And I believe in House Bill 1600, we just confirmed it was not placed back into the budget. So all the various counties for their career criminal, which is the next bill, as well as for victim witness assistance programs, right now are unfunded, although they're state mandated programs. So we would really appreciate the Judiciary Committee placing that money back into the budget so we can continue to run this program. Thank you.
All right, thank you. Anyone else here to testify on this measure, SB 2087? If not, members, any questions?
I do.
Rep. Nakamura.
For the prosecutor's office, so it was all at one point, the funding was in the state budget because it's a state mandated program.
It's in the state, it was originally in the state budget under ATG 100. I believe either last year or the year before, they zeroed out the career criminal as well as the victim witness assistance program money. And that was just one lump sum that is then broken down by the attorney generals to the different counties to support the career criminal units in each county. And so our bill, essentially the amount that's put in our testimony for this bill, as well as the following bill, is just strictly to basically return to the current level for our offices for the career criminal unit. But for all the other counties, they wouldn't be covered. So it would have to be either put back into the budget under ATG 100, or based on the title of these bills, it could be maybe addressed with all the different counties to be put in as one lump sum and then distributed through this bill, if that makes sense.
So currently it's just for the city and county of Honolulu prosecutor's office.
That's correct. That's
For the
correct.
next two bills or three bills. Okay, thank you.
Thank you.
Okay, members, any other questions? All right, if not, we'll move on to SB 2088 SD2, making an appropriation for the Career Criminal Prosecution Unit, which Mr. Tom has just talked about a little bit. You're up, Mr. Tom.
And
Honolulu prosecutors.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Again, I think we kind of generally went over this. I would just make note specifically because this bill, there's an amount in our testimony that only covers Honolulu. The base budget in ATG 100 is the one that would actually encompass the amount that we're requesting. And I believe it goes up to about 1.6 that covers all the other counties. So it's just something for the committee to look into to address for career criminal for every county that also has a division. Thank you.
Any other testifiers here for SB 2088 SD2? If not, members, any questions? All right, if not, let's move on to SB 416 SD1, relating to witness fees and reimbursements in criminal cases. First up, we have the Public Defender's Office in support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm James Taga with the Office of the Public Defender. We stand in our testimony in support of this bill. I just want to note that it's not every day that our office will support a bill that's part of the Honolulu Prosecuting Attorney package. So otherwise, we're here for questions. Thank you.
All right, everyone getting along now. Next up, we have Prosecutor's Office, Honolulu Prosecutors in support.
Thank you, Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Ditto for Mr. Tabe. We do both support the same bill, and that's not something that happens all the time, but this amount of money does assist in providing expert testimony in a number of cases, whether it's also court-appointed cases for defendants in criminal trials. One thing I would note that right now, as the interpretation by the Attorney Generals is for this bill, it would essentially, if the case pled out before trial started, we would not be able to recoup any of that expert witness fees. The only way that we would be able to do that is if we put the expert witness on the stand just to state their name and then bring them off the stand, just so we could collect witness fees that they incurred traveling from out of state or in state. Thank you.
Thank you. Any other member or anyone else here to testify on this measure, SB 416 SD1? If not, members, any questions? Yeah, sorry, Mark, I've got one question for you. So you said that this version of the bill, you could not recoup witness fees if it was pled out before trial. You need to put them on the stand. Is there a correction?
No, the way that this bill is,
right now it's fine.
Yeah, this will provide clarification for, I believe it provides enough clarification for the Attorney General is that those amounts for expert witness fees would be covered. I would note for Honolulu specifically, it's not just the state that's covering it. Depending on what type of mileage or travel it is, the city also incurs some of the reimbursement and the state. So it all comes out of this one fund that's already in the state budget.
Gotcha. Okay, thank you. Members, any other questions? All right, if not, let's move on to SB 1346 ST2 relating to juror compensation. There's actually no one here to testify here today that signed up. Anyone here in person to testify for SB 1346 ST2? Okay, let's move on. SB 2136 relating to jury services. First up, we have the Stonewall Caucus of the Democratic Party of Hawaii in support.
Good afternoon, Michael Goloyu Jr. On behalf of the Stonewall Caucus of the Democratic Party of Hawaii, we stand in full support of this measure and we encourage you to pass it. Mahalo.
Okay, thank you. Next up, we have the Hawaii Health and Harm Reduction Center in support.
Good afternoon, Vice Chair and members. Nikos Leverins with the Hawaii Health and Harm Reduction Center in strong support of this bill. This bill will strengthen Hawaii's non-discrimination laws against a category of persons who've suffered a great deal since the Western colonial contact, and we're making progress, and this bill is a good measure. Thank you.
Okay, thank you. Anyone here in person to testify on this measure? Seeing none, members, any questions? All right, seeing none, we'll move on to SB 2663 SD1 relating to filing fees. We do have two testimonies, written testimonies to support, but no one here to testify today. Anyone here in person to testify today on SB 2663 SD1? All right, seeing none, we'll move on to SB 2740 SD1 relating to guardians ad litem. All right, we have one testifier here today, Prosecutor's Office in support.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. The department stands in support of this measure. Thank you.
Okay, thank you. We do have a number of other individuals and organizations that have submitted written testimony in support. Members, any questions? Okay, seeing none, we'll move on to SB 2162 SD1 relating to ranked choice voting. First up, we have the Stonewall Caucus of the Democratic Party of Hawaii in support. Actually, he was just here. Is he still online? Just left. Okay. All right. No longer present. Next up, we have Common Cause Hawaii. In support. Sandy, you're up. No problem. We moved through the other ones kind of fast.
Oh.
This is for 2162 relating to ranked choice voting.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii, testifying in support of SB 2162. Common Cause supports ranked choice voting. This is a limited bill just to establish ranked choice voting for special federal elections and special vacant county council seats. We think ranked choice voting will really improve and modernize our elections here in Hawaii for these two special races. And that's because a lot of times a person will have more than one choice to vote for. And this will allow people to vote for more than one person that they think will best serve them in Congress instead of only having to pick one person. So a person could rank their order of preference for candidates for special federal elections and special vacant county council seats. Now, a person doesn't have to rank if a person doesn't want to, but a person may rank if they have more than one person they would like to see elected to office. So this could also tone down the rancor of our elections and have candidates really try to reach out to a broader base of people to gain their support. So for these reasons, we really support ranked choice voting. A lot of jurisdictions, over 50 across the nation, have adopted ranked choice voting. Thank you very much for allowing Common Cause to testify in support of ranked choice voting. And I'm available to answer any questions. Thank you.
Okay, thank you. Next up, we have League of Women Voters of Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Janet Mason from the League of Women Voters of Hawaii. We actively, strongly support this bill. This is the first year we crossed that threshold. In the past, we were providing comments only on the ranked choice bills. But now we have reached a point where we think there's plenty of evidence from other localities that voters can understand a ranked choice ballot and can execute it well. We support all the voter education efforts described in the bill, including the provision that the election proclamation should announce that it is a ranked choice method that would be used in the election. And we're pretty excited about this new reform in Hawaii. I'm happy to answer any questions you might have.
Thank you. Members, we have about 15 individuals who submitted testimony, all in support, one in opposition. Two here are, or two should be here to testify. First up, we've got Benjamin Reilly in support.
Thank you, Mr. Chair. Thanks for the opportunity. Yes, my name's Ben Reilly. I'm a adjunct senior fellow at the East West Centre. I'm an Australian political scientist. We've used ranked choice voting in Australia for 100 years. And I happen to have studied ranked choice voting, so I thought it might be a good opportunity to say a few words in support of this bill. As Sandy Ma said, a big advantage of ranked choice voting is for voters. If you have a degree of preferences between different political parties, you can actually show it on the ballot without worrying that you might hurt one of the parties that you wish to vote for. So you can vote for, say, a smaller party with your first vote and then give your second or third ranking to which of the bigger parties you prefer. And that's a big advantage for a lot of voters who would otherwise have to not always vote sincerely, as we say in political science. A second advantage is for politicians. Ranked choice voting means that a vote for an opponent can sometimes come back to you as a rival politician if you're close and voters for that opponent gave you a second or third ranking. And so that's quite useful, that it's not so much of a zero-sum game when you're contesting elections. There are times when it pays to actually collaborate with opponents, or at least to be a bit more cooperative than is the case under the current plurality rules. And finally, for that reason, ranked choice voting across the nation is seen as a beneficial reform for the political system. I've been involved in ranked choice voting take up in Maine and Alaska, and there's a lot of evidence that it helps this problem of polarization. I think it's not as big a problem here in Hawaii, but it's certainly a problem in other parts of the country. So for that reason, I support this bill. I'd be happy to answer questions, and thank you.
Thank you. Next up, we have Brianna Harmon in support. If not present, that's all the testifiers we have signed up. Anyone else here to testify on SB 2162 SD1? Okay, seeing none, members, any questions? Yep. Seeing none, we'll move on to SB 2623 SD2 relating to the Hawaiian Homes Commission Act. Got one testifier up today, THHL with comments.
Hi, good afternoon, Chair, Vice Chair. Testimony on Senate Bill 2623. We stand in support and would be ready for any questions.
Okay, anyone else here to testify on this measure? Seeing none, members, any questions? Nakamura.
Thank you,
Representative.
Director Ayla. I have a question about the 176 families. What are they? Are they living in a DHHL unit and then they're selling the unit? Is that what's going on here?
No, not necessarily. I think a small minority of those are selling. The majority of the respondents indicated that they were giving it to family members. So the transfers, the vast majority of transfers are occurring to family members.
Okay.
No compensation. The commission 2 years ago made a policy which was followed through in administrative rules, so that if you have an undeveloped portion of land, there were vacant lots that were given out in the late 1980s, early 1990s through the Accelerated Award Program. Many of those, because they do not have infrastructure, remain unoccupied. In the past, people were able to sell the lease to that non-developed land. We now have rules, anything that's not developed is not able to be transferred for a fee. Family members can still transfer it to other family members.
And then for those who sell, there's a small percentage of the 176
Yes,
families
yes,
who actually can sell their land.
yes.
And what happens after they sell their land?
Some of them just continue with their lives. Others, the small percentage, go back on the wait list.
They
But
can sell and go back on the wait list?
Yes, but they go to the bottom of the wait list. So they don't, okay, but I think part of the intent of this measure is not going to be effective, because any 50% Hawaiian can transfer their lease to another 50% Hawaiian, irregardless of whether they're placed on the wait list. Okay, that's how homes are being sold now.
I see. It's just directly to someone on that list?
Yes, yes. And we're torn, because we actually went out to beneficiary consultation about 2 years ago, and half of the responses that we got statewide was that should stop. The other half was it should be allowed because people are taking the equity out of their homes, oftentimes to help their children build another home, or they have health problems and medical bills. So, we can see it from both sides. And because there's no clear indication, no effort has been made to stop the transfer for sale of developed lots.
Thank you.
You're welcome.
Members, any other questions? Chair, I do have one question for you.
Yes.
Of the leaseholds interests that are sold for monetary, not just transferred for no gain, but that were actually sold, how many of those people decided to go back on the wait list? And then of those people, how many actually got another lease?
I would say very small numbers, less than 20. the majority, I think
And that's less than 28, not a year, but you're talking total.
20
Okay.
in the last 10 years.
Okay.
What frustrates people is you have a person who has the means, they're 50%. They go and purchase a parcel from someone else, then transfer it to their child. Then they go and purchase another parcel from another homesteader and give it to their other child. But that is irregardless of the wait list, because they're 50% and the seller is 50%. They're not getting on the wait list to get another parcel of land. They're just purchasing because they have the means.
And to be clear, that situation you just described would not be affected by this bill at all.
No.
Okay. Thank you. Members, any other questions?
Yeah, I do have a question. Chair, you indicated that there was support, but your testimony is kind of more commentary, and it sounded like this bill was unnecessary from the commission's point of view. Is that accurate? Or is that
I
my
would say-
reading
I would
accurate?
say the introducer of the bill feels it's very necessary, and this is, I think, the third session that it's been introduced. It would help in the limited number of cases, but it's not going to stop the 50% are selling it to someone else.
Okay. All right, thank you. Members, any other questions? If not, we'll move on to SD 3041 SD2, making appropriations for claims against the state, its officers, or its employees. First up, we have the AG's office in support.
Good afternoon, Chair, Vice Chair, members of the committee, Karen Inagaki, Deputy Attorney General. The department does support SD2, but with amendments. We have several concerns about this version of the bill. All the amounts were taken out, and Section 6 suggests that the amounts can be altered or reduced. The problem with that is that, the judgments cannot be unilaterally changed, the terms of a settlement, and the judgments cannot be altered or amended without a court order. So we would ask that the bill be passed, but that Section 6 be deleted and that the amounts all be reinstated. There are 3 new claims also that should be added to the bill. They are described in attachment B to our testimony. Thank you for the opportunity to testify, and I am available for any questions. Thank you.
Okay, thank you. Next up, we have DLNR with comments.
Good afternoon, Chair, Vice Chair, and members of the committee. David Zakota with the Division of Aquatic Resources for DLNR. We'll stand on our written testimony, offering comments and requesting that as to Part 3, Section 3 of the bill, the appropriation be taken from the State General Fund rather than from the department's operating budget. I'm also available for any questions. Thank you.
Okay, we have another DLNR person, David's. We have 2 DLNRs signed up to testify. I'm assuming that you're testifying on behalf of DLNR generally, right?
Yeah, that's correct. Brian couldn't make it.
Thank you. Okay, next up we have the Department of Education with comments.
Aloha, Chair, Vice Chair, members of the committee, Albert Tiberi on behalf of the Department of Education. We stand on our written testimony. Thank you for the opportunity to testify.
Okay, thank you. Anyone else here to testify on this measure in person? Okay, seeing none. Members, any questions? Okay, seeing none, we'll move on to SB 2291 relating to electronic eavesdropping. First up, we have DCCA in opposition.
Good afternoon, Chair, Vice Chair, members of the committee, Kat Awakuni Cologne on behalf of the Department of Commerce and Consumer Affairs. The department stands on its written testimony, respectfully opposing. We have concerns with respect to the civil enforcement authority of the department and some of the broad language around, what is considered government records. I'd be happy to answer any questions you may have. Thank you for the opportunity.
Okay, thank you. Next up, we have AG's office in opposition.
Afternoon, Deputy Attorney General Brian Yee on behalf of the Department of the Attorney General.
we are testifying in respectful opposition to this measure. The purpose or the intent of this measure is to conform to the decision in the Carpenter decision, as well as to conform to existing law enforcement practice. This bill is not necessary to conform to the Carpenter decision, and it does not conform to existing law enforcement practice, at least not to all law enforcement practices. The Carpenter decision found that there is a requirement for a search warrant when you're trying to get cell site locations. In other words, you're trying to get, you're trying to triangulate and locate where a person was at a particular point in time. And so you get information from these various cell towers to find out that information. And the Supreme Court said, well, for that, you need a search warrant. And that is no different than what we are doing here, and is no different than our practice in Hawaii. And even if the law was inconsistent, the Supreme Court decision would obviously apply, and a statutory change would be unnecessary. So it is not necessary to pass this bill for that purpose. In addition, however, the bill does much more than the Carpenter decision. And as I said, it's inconsistent with all law enforcement practices. This bill will take away the ability of law enforcement to obtain certain limited information related to electronic communications, but not the content of the communications itself, things like an email address. It will take away the ability to obtain this information through subpoena, and would instead apparently require search warrant for all electronically stored data, where electronically stored data is a new term that is created, and it is defined very, very broadly, as you might imagine. Many pieces of information are now electronically stored data. Consequently, we are concerned that this bill will, which deletes the existing law, our existing law, which complies with the Electronic Communications Privacy Act, will be detrimental to law enforcement, and therefore we ask that it be held. If it is not held, we have mitigating measures to at least
Mr. Berger, that's been 2 minutes. If you could conclude your testimony.
Sure. Just to summarize, we've proposed some mitigating measures if you do pass it, but it will not solve all problems, and therefore we respectfully ask that the bill be held.
Okay, thank you. Next up, we have HPD in support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Captain Jared Hiramoto of the Honolulu Police Department. HPD is in support of Senate Bill 2291, and we stand by our written testimony. Thank you for this opportunity, and we'll be standing by for any questions.
Thank you. Next up, we have Honolulu prosecutors in support.
Good afternoon, Chair, Vice Chair, Chris Fairmorter, Deputy Prosecutor. I'm here not only as a member of the Prosecutor's Office, but I was a member of the 21st Century Privacy Law Task Force. A couple of points I want to make. The task force unanimously recommended this measure to the legislature. This task force was created as a result of a House concurrent resolution. It asked the task force to generate proposed legislation. This is one of the bills that the task force generated and submitted to the legislature in a report to the legislature in February 2020. The last, well, not the last speaker, but the AG speaker and the Department of Commerce and Consumer Affairs speaker, their departments were members of this task force. And so the first point I want to make is neither of those departments objected to this measure. There wasn't a single member of the task force who opposed this measure. This measure was unanimously adopted by the task force. The second point I want to make is this is not the first time that the legislature is considering the language that's in SB 2291. This exact language was in a bill in the 2020 legislative session, House Bill 2572. That bill was taken up by the House, including the Judiciary Committee, although it looked much different in 2020 than it does today. But the House Judiciary Committee passed this exact language in House Bill 2572 in 2020. No objections. It went through every committee in the House and passed and went to the Senate. If you go back and look at House Bill 2572, did the Attorney Generals object when this was first proposed to the legislature in 2020? They did not. Did the Department of Commerce and Consumer Affairs object? They did not. The first time they've objected was in the last couple of weeks. And so a couple of major points that I want to make. We are the largest prosecutor's office in the state, over 100 prosecutors. HPD is the largest police organization in the state with almost 2,000 police officers. If we thought, and HPD thought, that this was going to impede what we do, we would not be supporting it. We are the most experienced prosecutors and police in cybercrime and white-collar crime in the state. I've personally signed over 1,500 search warrants. This will not impede our ability in any way to do our job. As far as the Carpenter decision, if you read the committee report.
It's been 2 minutes. If you could start to conclude your testimony, please.
Okay, well, I'll just end with this. If the largest prosecutor's office in the state, the largest police officer in the state agree with this, and we can balance privacy and facilitate law enforcement, if we believe that, we would submit that you would have some confidence in the two largest organizations being able to do privacy and law enforcement. It's not an either-or choice. Thank you.
Okay, thank you. We also have testimony from the Kauai prosecutors in opposition and the Kauai Police Department in opposition. Anyone else here to testify for SB 2291? Okay, members, any questions? Rep. Pressi.
So prosecutors were supposed, which Bureau of prosecutors?
Honolulu
I'm
prosecutors.
confused. You're Honolulu prosecutors. Who was the prosecutors opposed?
Kauai.
Hawaii County. You were gonna say a few more things about your reasoning on this, and I'd like to hear you out.
Well, what I wanted to point out was, right now, under the statute, it says that we can use a court order to get cell site data. They say this doesn't have to be changed. The Supreme Court says it has to be changed. The United States Supreme Court says we can't use a court order to get cell site data, but our statute as it exists right now today, I can use a court order to get cell site data. But more importantly, what the Attorney Generals want is that they want to use subpoenas issued just by prosecutors to know who you're calling, who's calling you, who's texting you, who you're texting, who your profile is with your Gmail or your Apple ID. They want all of that without any judicial oversight. And we're saying, I've done over 1,000 of these search warrants. There should be judicial oversight because we're invading people's privacy. I have seen it firsthand, what we get back from Google and Apple and Microsoft. It's extremely intrusive. If we have a judge in the room, it provides some limiting scope to what we're asking for. It doesn't become this big fishing expedition. So I think it's important for the privacy of everyone that a judge review our request and decide whether it's proper or not, versus the current system just allows us to use a subpoena without any judicial oversight.
So I tend to agree with that reasoning, but my question with that information is, because the Fourth Amendment is supposed to protect us from unreasonable search and seizure, right? And if it was my papers, my physical papers in my home office, you would have to get a search warrant.
Correct.
Right?
Correct.
And when the founding fathers wrote this about illegal search and seizure, they were talking about our papers, but today, right, this is my papers. And so that's why I strongly support
it
that.
contains a voluminous amount of paper, albeit in digital form.
I agree. Thank you. Thank you, Chair.
Any other questions? Rep. Pioca.
Hi, Chris.
Oh.
You've been around a lot. And what was just puzzling to me just now was your office and the Honolulu Police Department supports it and Kauai doesn't support it. So my question to you is, who was on this task force and how come everybody's not on the same page? You have the Attorney General in opposition, and I've worked with you for a long time. I trust what you say. You've never come here and told us stories. So why the different testimonies?
So
in your mind anyway, and I'll ask the Attorney General's office.
Sure. So when this bill was heard in the Senate last month, those questions were asked, I believe it was by Senator Rhodes, the Judiciary Chair of the AG. And basically what they said was that they sent to the task force a civil attorney, not a criminal attorney. And the civil attorney, when he went back to the office with the proposals recommended by the task force, those proposals weren't disseminated for the whole office to provide input. So the person who testified last month, Michelle Fugu, she said they didn't know about this proposal. And so, there was a lot of surprise among the members of the Senate, including Chris Lee, who was the chair of the task force. Now he's at the Senate side. And it's like, what, your office didn't object when we considered this, and you didn't object in 2020 when it was first considered. So we were all confused. That was the explanation they gave, that it wasn't disseminated. I didn't represent my office on the task force. I didn't represent myself. All the proposals that the task force recommended were disseminated to my office, and I had input from our 100 attorneys. I assumed that the AGs had done that consumer protection, Steve Levins was on the task force for DCCA. We all assumed that they disseminated the proposals and that their office was weighing in versus an individual attorney weighing in. So that's the explanation we had last month.
So did this task force have minutes or a digest that the different departments would have gotten? Because I'm just puzzled. I'm baffled actually.
Yeah, well,
the testimony is so different.
Yeah, the task force generated a report to the legislature, and it's all in here with over 100 footnotes.
Okay.
And that's why I was so surprised last month, because the AGs didn't object, and when it was heard in 2020, they didn't object. And as I said, we have the biggest police department in the state, the biggest prosecutor's office in the state. We believe we can balance privacy and still do our work without impeding investigations, and we do it every day. We've been using search warrants exclusively since 2014, and we haven't had any difficulty in investigating or prosecuting.
Yeah. And the co-ed prosecuting attorney's office is brand new, like less than a month she's been there. Oh, she was there in a different capacity, but I'll follow up with her. So, Vice Chair, can I ask the Attorney General?
Yeah. Why don't we hear from AGs?
Yeah. Is the Attorney General outside or?
No, they're on Zoom. AG's office, are you still there?
Yes,
Did you hear my question to Mr. Van Matter?
I did. And in fact, I was the representative of our office on the 21st Century Task Force, Privacy Task Force. So I was there with Mr. Van Marter. I will say that what happened, I was chosen, frankly, because I deal with consumer protection. And so issues of consumer protection privacy, whether or not consumers are being adequately informed of the information that they're putting into Google and Amazon and all the rest. That was actually my primary interest. It was the reason I was chosen for the task force. When this particular matter came up for the task force, I perhaps incorrectly relied on the Homeland Prosecutor's Office's representation that this bill simply conformed state law to the Carpenter decision and was consistent with existing law enforcement practice. Perhaps that was a mistake, but I relied upon that representation, and based upon that, didn't see a problem with the bill, and so didn't raise an objection. I was then informed of my error, and that is the reason we have testified in opposition, because the bill does not simply conform to the Carpenter decision, and it is not consistent with existing law enforcement practice.
Okay, thank you, Vice Chair.
Any members, any other questions? Okay, seeing none, we'll move on. SB 3044 SD1 relating to tobacco manufacturer qualified escrow funds. First up, we have AG's office in support.
Good morning, Chair Nakashima, Vice Chair Matsuyoshi, and members of the committees. I'm Deputy Attorney General Chelsea Okamoto from the Attorney General Tobacco Enforcement Unit, substituting in for Deputy Attorney General Rich Stacy. The department is in strong support of this bill. The committee previously heard the companion bill, HB 2076, which is being heard tomorrow in the Senate Commerce and Consumer Protection Committee. This measure provides a useful tool for the state to be able to assign these tobacco manufacturer escrow account balances to the state of Hawaii. As part of the master settlement agreement, certain tobacco manufacturers are required to deposit monies into these escrow accounts, but some tobacco manufacturers stop selling these tobacco products and they want to turn over these escrow funds to the state. Hawaii law, however, only allows release of these funds under very specific circumstances. And this bill will provide a mechanism for the state to obtain these escrow monies. There's other states that have these escrow assignment statutes, and this bill was modeled after Oregon statute. California has had a lot of success with their escrow assignment statute and has successfully obtained hundreds of thousands of dollars in escrow funds. And we believe that this measure will help Hawaii have similar success. Thank you for the opportunity to testify, and we ask that this bill be passed, and I'm available for questions.
Thank you. Anyone else here to testify on this measure? Okay, seeing none, members, any questions? Okay, seeing none, we'll move on to SB 3114 SD2 relating to marriage licenses. First up, we have the Department of Health in support.
Thank you, Chair, Vice Chair, members of the committee. Lauren Kim again. I'm the Policy and Planning Officer. But for this bill, I'm wearing my alternate hat as the acting state registrar. We are in strong support of the bill as drafted, minus defective dates and technical issues. This bill does two things. Number one, it establishes parity for all types of marriage performers, and it introduces a fee across the board with the monies from which go to the Vital Statistics Improvement Fund. So the department processes dozens of requests for licenses for marriage performers on a weekly basis. This is the person that says, do you take this person to be your lawfully wedded so-and-so? We have not charged for that ever. And these individuals generally run small businesses and will turn around and charge local and out-of-state couples anywhere from $100 to $500 to be a marriage performer. So we think that this, in the words of the very wise conferee last year, the state should get a cut of this because they are acting as agents of the state, and money should be deposited into our Vital Statistics Improvement Special Fund so that we can continue to improve our operations and service to the public. The department doesn't make any money off of anything related to our marriage performer licensing activity or our marriage licensing activity. And that's a separate issue for which there's a separate bill, but I just wanted to share that background to you. So once again, we stand in strong support of this draft and I'm available for questions. Thank you.
Thank you. Anyone else here to testify on this measure? Okay, seeing none, members, any questions? Seeing none, we'll move on to the last bill on the agenda, SB 2456 SD2 relating to identification cards. First up, we have DOT in support. DOT is not here. Next up, Common Cause Hawaii with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We're providing some comments on SB 2456. We do support providing special purpose identification cards for people who are not able to provide all the identification, all the documentation necessary to secure real IDs. We just want to make sure that given that this legislature passed automatic voter registration last session, that those people who have the right to vote are also able, with automatic voter registration, able to enroll in the process of automatic voter registration through the special purpose identification if the processes are compatible and appropriate. So that is our comment. Thank you very much, and I'm available to answer any questions. Thank you.
Thank you. Next up, we have the Hawaii Friends of Civil Rights in support. Amy, are you there? You got to turn on your camera and unmute yourself. Amy, you can go ahead when you're ready. Amy, we can see and hear you. You can proceed with your testimony.
Are you
Oh,
talking to me?
Yes.
Oh, thank you. I'm representing Hawaii Friends for Civil Rights. We strongly support this measure and I stand by my written testimony.
Okay, thank you. Next up, we have the Hawaii Coalition for Immigrant Rights in support. Okay, not here. Last, we have the one individual testifying today, Robert Mercy, in support.
Yes, Chairman Nakashima and Vice Chair Mariyoshi, my name is Bob Merce. I'm a retired lawyer who served on the Reentry Commission in 2018 and 2019. One of our main focuses and our main concerns was making sure that people coming out of prison could function in a 21st century society, which we know they can't without IDs. So we don't have any state issued IDs for people coming out of prison. This would be very important to help them get restarted in the community. It would certainly reduce recidivism and it would probably make our community safer. So we urge you to pass this bill. Thank you.
Thank you. Is there anyone here? Is there anyone else here to testify on this measure? Okay, seeing none. Members, any questions? Okay, seeing none, we will recess for decision making.
Okay, reconvening the House Committee on Judiciary and Hawaiian Affairs, Tuesday, March 15, 2022. Conference room 325. Hey, members, we're back for decision making on Senate Bill 2111 relating to public notices. Chair's recommendation is that we defer this measure based on concerns expressed during the discussion on Senate Bill 2390, Senate Draft 2, related to the Judiciary. Chair's recommendation is that we just further defect date this to January 1st, 2022, so that the bill with the defect date won't automatically go through. Members, any questions or comments?
Chair.
Representative Lupresti.
Thank you. Just ruling on a potential conflict of interest.
Yes, you state your conflict.
I have a case before the Intermediate Court of Appeals for quite a while, actually.
Yeah, no conflict. Thank you very much.
I support it because.
Members, any other questions or comments? Okay, seeing none, Vice Chair, as amended.
Yeah, Chair's recommendation is pass SB 2390 SD2 with amendments. Chair and Vice Chair vote aye. Rep. Ichiyama.
Aye.
Rep. Kobayashi.
Aye.
Rep. Lopresti.
Aye.
Rep. Lowen.
Aye.
Rep. McKelvey. Excuse. Rep. Nakamura.
Aye.
Rep. Takumi.
Aye.
Rep. Tokioka.
Aye.
Rep. Ward.
Aye.
Hey, Chair, your recommendation is adopted.
Okay, thank you very much. On Senate Bill 2087, making appropriations for Victim Witness Assistance Program. Chair would note that we should add Honolulu after county on page 1, line 8. Chair would also like to further defect date this January 1st, 2022. Members, any questions or comments? Representative Nakamura.
Yeah, this bill I will support this bill. I just want to note that the neighbor islands will not receive funding for the same services that they're providing. And I know that Kauai County for this and the next bill also does not have funding and would like to have funding to do this important work. Thank you.
Chair's cognizant of the concern and believe the title might be broad enough to add that in. Chair will probably make a note in the committee report to finance to consider that.
Thank you.
Okay. Members, any other questions or comments? Okay, seeing none, Vice Chair as amended.
Chair's recommendation is pass SB 2087 SD2 with amendments noted previously. Excuse member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 2088 SD2 appropriations for the Career Criminal Prosecution Unit. I guess the same comments that we further defect dated January 1st, 2022, and indicate the need for funding for other counties as well. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 2088 SD2 with amendments noted the previous excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 416 relating to witness fees and reimbursements in criminal cases. Chair's recommendation is amendments of technical amendments for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 416 SD1 with amendments noted to the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 1346 related to juror compensation. Chair's recommendation is that we further effect dated to January 1st, 2022. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 1346 SD2 with amendments noted to the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 2136. Chair recommends that on line 5, we adopt the HRS phrase where instead of gender identity or expression, we indicate it as sex, comma, including gender identity or expression. So that would actually be on line 5. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 2136 with amendments noted to the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. Senate Bill 2663, Senate Draft 1, related to filing fees. Chair's recommendation is to amend it with technical amendments for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 2663 SD1 with amendments noted to the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. Members, Senate Bill 2740, Senate Draft 1, related to guardians ad litem. I will note that the appropriations has been blank and it contains a defective effective date. I would like to further defect the date to January 1st, 2022. Make a note in the committee report for $100,000 as the cost for this item. And that would be it. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 2740 SD1 with amendments noted to the previously excused member. Any members voting with reservations? Any members voting no? Recommendation is adopted.
Thank you very much. Senate Bill 2162, Senate Draft 1, related to ranked choice voting. Members, on page 4, line 9 to 12, the section provides for that in the event of a tie between candidates for the most votes or between last place candidates, the candidate chosen by lot should be defeated in the event that there's a three-way tie between candidates for the most votes. This process will not decide the winner. So what I would like to do is insert language there to specifically in Part C, a tie under this section between the candidates for the most votes in the final round or in a tie between the last place candidates in any round shall be decided by lot, and the candidate chosen by lot shall be A, declared the winner if the tie is between candidates for the most votes in the final round, or B, defeated if the tie is between last place candidates in any round. Other technical amendments for clarity, consistency, and style. And to further defect date this to January 1st, 22. Members, any questions or comments?
Chair.
Representative
Comment.
Ward.
I think you demonstrated very well with that amendment, how difficult it is to understand this. So it's going to be confusing to the people. And in my humble opinion, it's an uneven playing field, and the super majority can only get bigger because it's easier to get elected on one side of the aisle than the other. And this kind of bias is that top two candidates are most likely going to be Democrats. Let's be very frank. And I think we need a bit more balance. We are now 4 to 47. Not exactly the best Democratic balance. Thank you.
Thank you very much. Any other comments or questions?
Just a quick comment. I would
Representative
debate my friend Representative Ward to say that you're gonna have Republicans and Democrats on the same ballot, which how it is now is it won't be that way. So I disagree with what your thought process is, and I think it makes it fair for any candidate of any party.
We will
At first, I didn't think this is a good idea, and I don't even know if I still think it's a good idea, but it's fair for all of the parties to be on the same ballot.
I asked the Office of Elections to explain it to my staff because they were trying to ask me. I said, call them. And they said they didn't know how to explain the one from the last session and the session before. So if we're confused in this building, can you imagine what's out there in the street?
I agree with that part.
Okay.
Thank you, Chair.
Okay, members, Representative Lopresti.
I just want to say why I support this. I mean, with the first race I was ever involved in, there was 14 candidates, and the guy who won got like 5% of the votes because he was the only person who was at that time against rail. Everybody else was for rail, and 95% of the people who voted in that election were basically for it. But the guy who won was the one guy against it. And, you know, he never got elected again. And that's this kind of thing prevents that sort of fiasco from happening. When everybody supports something or feels one way, or most people support something or feel one way about it, you get one fringe candidate and they can take all. And that's what this helps prevent. That's what I support.
Okay, members, any other questions or comments? Seeing none, Chair's recommendations passed as amended. Vice Chair.
Chair's recommendation is to pass SB 2162 SD1 with amendments noted the previously excused member. Any members voting with reservations? Any members voting no? Our board with a no. Any other members voting no? Okay, Chair, your recommendation is adopted.
Okay, thank you very much. Senate Bill 23, Senate Draft 2, relating to the Hawaiian Homes Commission Act. Chair's intent was to defer this. However, based on the department's testimony today, we would like to move it along to continue discussion with technical amendments needed for clarity, consistency, and style. So with that, members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 2623 SD2 with amendments noted the previously excused member. Any members voting with reservations? Any reservations for Rep. Nakamura? Any other members voting with reservations? Any members voting no?
No for Kobayashi.
No for Representative Kobayashi. Any other members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 3041, House Senate Draft 2, making appropriations claims against the state, its employee officers or employees. I would like to adopt the AG's amendments requesting 2 additional claims to delete section 6 from the measure lines page 6 lines 5 to 11, I think it is, to be further defect dated to January 1st, 2022, And make a note in the committee report that the charter school suit should be paid for by the Department of Education. Other technical amendments needed for clarity, consistency, and style. Oh, yes. And to confirm that Earth Justice cited 2 settlements and are correct and should be adopted amounts that are currently blank in SD2 for $132,611.87 for the Kalekai and $145,736.28 for Kupiko. Also restoring all of the other amounts that the Senate previously blanked out in the bill. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 3041 SD2 with amendments noted the previous excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 2291, electronic eavesdropping. Chair's recommendations that we defer decision making until March 17, 2022 at 2 p.m. in this room. SB 3044 SD1 related to tobacco manufacturing qualified escrow funds. For this one, technical amendments needed for clarity, consistency, and style. And that's it. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 3044 SD1 with amendments noting the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, SB 3114 SD2 related to marriage licenses. Chair's recommendations to pass it out as is. Members, any questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass SB 3114 SD2 as is, noting the previously excused member. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
And finally, SB 2456 SD2 related to identification cards. Chair will note that the House Bill 1761 is being considered by the Senate Transportation today at 3 o'clock. So they might be finished by now. However, based on that, we will wait to find out the Senate decision and postpone decision making on this until March 17th, 2022 at 2 o'clock in this room. Members, any questions or comments? Okay, seeing none, we are adjourned. Thank you.